A Cook County judge has found that Chicago Mayor Emanuel and his office violated state law by withholding for nearly a year and a half emails sent and received from his personal accounts that related to city business, including emails about the scandal-plagued red light camera program. Circuit Judge Kathleen Pantel agreed with the Chicago Tribune that Emanuel and his office violated the state's Open Records Act by belatedly releasing the emails, handing the newspaper a victory in its ongoing court battle over the mayor's use of personal devices and accounts to conduct the public's business. In addition, the judge opened the door to having Emanuel testify about whether he and his office failed to preserve texts and emails on his personal phones and accounts in violation of another state law relating to the preservation of government records. Bill McCaffrey, spokesman for the city's law department, said the city has had a process in place to periodically release emails relating to city business from Emanuel's personal devices and accounts. He declined to comment further. Still, Emanuel maintains that emails and texts on personal cell phones and accounts are not subject to the state's open records law, known as the Freedom of Information Act. He has argued that the Open Records Act does not require governments to search personal cell phones and email accounts for records about public business. Pantel previously rejected that argument and did so again in Monday's ruling, a ruling that writings pertaining to the transaction of public business are not public records would open the door to allow unscrupulous government officials to shield public records by the simple expediency of conducting public business with the use of personal devices and impersonal emails, Pantel wrote. Under the Open Records Act, the Tribune in June 2015 sought emails and text messages about the city's controversial red light camera system. Separately, it also asked for electronic communications between Emanuel and Michael Sachs, chief executive of a Chicago hedge fund who has donated to Emanuel's political campaigns and was picked to lead World Business Chicago, which the mayor formed to bring business to the city. The mayor's office refused to even search for any communications from Emanuel's personal cell phones or on his non-city email accounts in response to the Tribune's request. The Tribune sued in September 2015, alleging Emanuel and his office violated the Open Records Act and the Local Records Act relating to the preservation of government documents, including emails and texts. In a settlement in December 2016 with the Better Government Association, which also had sued the city, the mayor's office released emails that had resided on Emanuel's personal cell phones and his non-city email account that pertained to the transaction of city business. At the same time, the city also released emails about public business in response to the Tribune's prior requests. Emanuel, however, turned over no text messages, which the Tribune's lawsuit had requested. Pantel found that the belated production of undisputedly public records from the mayor's email accounts violated the Freedom of Information Act. The Tribune last month also asked Pantel to find that Emanuel and his office violated the act relating to the preservation of government documents. The mayor, through a spokesman, has acknowledged that emails sent to his personal accounts were deleted after 90 days and it appears that text messages may also have been automatically deleted. Pantel, however, was not ready to find that Emanuel also broke the Local Records Act. She noted that the Tribune is allowed to pursue through court discovery whether Emanuel and his office allowed public records to be destroyed when the texts and emails were deleted, including deposing the mayor or any other witness with personal knowledge on this subject. For its part, the city noted that in late December 2016 it issued a new policy barring employees from using their personal devices and non-city email accounts to conduct government business. Any email employees receive on their personal accounts that relate to city business must be forwarded to their city-issued email account. The city has never turned over any texts in response to the Tribune's request. The Tribune contends that texts relating to public business were deleted or not properly retained. The city refused to answer any interrogatories where certain records were not preserved. Instead, the city filed an affidavit from Emanuel's personal lawyer stating that text messages cannot now be located on the mayor's phones. In her ruling, Pantel noted that Emanuel and his office have produced no evidence on the actual issue in this case, whether public records stored on the mayor's phones or in his privately owned email account existed and then were destroyed. Defendants now try to sidestep the issue by arguing that they voluntarily adopted a policy on the use of mobile devices by city employees, but Pantel said it was unclear whether the policy applied to the mayor. More important, she wrote, the policy could be changed at any time. To Lighty at ChicagoTribune.com, Twitter at Todd Lighty. Related, Emanuel will turn over personal cell phone for review in battle over texts. Emails to Emanuel raise questions about dozens of possible lobbying violations. In Emanuel emails, some lobbyists registered but didn't report contacting mayor.